Hello everyone. Today, an important topic more than the price hike of petrol, diesel and LPG is Gyanvapi Masjid. More than inflation, more than unemployment, more than education, more than financial crisis, an important topic here in India to be discussed is Gyanvapi Masjid, to whom it belongs. It is the important topic. It is obviously, it must be discussed as per the BJP agenda and the rule. Who could have thought that an argument for syncretism and the blurry nature of culture can be used to first enter the religious or sacred places of non-Hindu communities, and they can lay claim over them. Ironically, this is what an observation by a three-member bench of the Supreme Court hearing the petition by the Masjid Committee of the Gyanvapi Mosque seems to be doing. The Masjid Committee had come on the highest, the Masjid Committee had come to the highest court aggrieved by the order of a Varanasi court leading to the survey of the Masjid to find out whether the Hindu religious signs and deities are present in the Masjid or not. The lower court had responded to the plea of 5 Hindu women who wanted to pray in the mosque, claiming their deities reside there. The Masjid Committee opposed this plea. Actually, the Masjid Committee opposed this plea. It said that the suit was not maintainable as the act protecting the status of the religious spaces as they were on August 15, 1947 was in place. In fact, it was this very Supreme Court, which had held that the act needed to be respected, that particular act to protect the places of worship act. That particular act needed to be respected and enforced to safeguard the secular nature of the country, to preserve harmony and peace in society. The aim of the act was not to allow any attempt which would lead to a Babri Masjid-like situation again. That is, the real motto of that particular act was not to lead a Babri Masjid-like situation again, but the clear intention of the BJP and the ruling party there over in UP, and even the petitioners, even the courts, even the survey people, entirely it was pertinent and it was evident to note that their intention and motto was to lead a Babri Masjid-like situation again. That was again. So that was the reason. Even yesterday it was, everyone would have noticed that yesterday it was trending in Twitter to revoke the act, to revoke the Places of Worship Act 1991. For what? Again, to create a Babri Masjid-like situation in this country. Again, to make this country, again to humiliate this country, again to make this country shame in front of other countries in terms of preserving the rights of religious minorities. So what happened? Before the maintainability of this suit could be decided, the Varanasi court raised to order a survey of the mosque by constituting a committee of lawyers headed by a Hindu lawyer. See how it could be justified. A committee, it has been constituted by the court, but it is headed by a Hindu lawyer to find out whether there is a structure of temple or Hindu deities or not. To find out there is a survey committee, and the committee was constituted by the court itself, but it is headed by a Hindu lawyer. Okay. The survey work started with an extraordinary sense of urgency. Muslims objected. They also found the conduct of the head of the committee partisan. But the courts ruled against the Muslims and asked the committee to go ahead, adding insult to the injury, adding 2 more Hindu members to the committee. Already it was fully filled by Hindu members in the committee, and it was headed by a Hindu lawyer. It's not a fault to be a Hindu or a Muslim or a Christian in a democratic country, in a secular state like India. But what the point I would like to make here is that that particular committee is constituted to find out whether there is a Hindu religious belief structure or not. So for that, it must be constituted in a secular way. It must be constituted in a harmonious way so that justice could prevail. But adding 2 more Hindu members to the committee, what it would do then? It is a broad daylight massacre of democracy in the very first itself. The Allahabad High Court, which had very firmly thwarted all earlier attempts before. Previously, they approached the Allahabad High Court, but the Allahabad High Court, which had very firmly thwarted all earlier attempts to justify the Hindu claim over using the finding of such surveys, this time did not find the survey problematic The survey started and the Masjid Committee was compelled to come to the Supreme Court seeking a stay on the process. But the Apex Court acted in a leisurely manner and did not think it necessary to stay the survey. Its indifference to the concern of the Masjid Committee was disturbing. The court let the matter drag on for nearly 4 days. The court led to drag on the matters for nearly 4 days. Meanwhile, the survey committee leaked information that a Shivalinga was found during the survey. Is it legal? Is it allowed in a country run by the law? So what they did, they leaked. The survey committee leaked information. What was the duty of the survey committee? The survey committee constituted by the court, they must produce their information in front of the court in a secretic manner. So what happened? The survey committee leaked the information that there was not Shivling at all, but wantonly, intentionally what they did to disturb the public order in the country. Again, to create a Babri Masjid-like situation in this country, deliberately they did this. They leaked an information stating that there was a Shivlinga in the fountain of the house of the Masjid. What happened then? The Varanasi court, without even having the report of the committee, which could not be the final, as the survey was still in progress, rushed to order that the place where the Shivlinga was allegedly, the claim was made that Shivlinga was there, supposedly found, should be sealed and made out of bounds. How is it possible in a democratic country? Without even constituting, without even getting the entire report, without even getting the survey report from the committee finally in a final manner, what the court did, the place should be sealed and made out of bounds. And then what happened then? It was this order which was challenged by the Masjid Committee. But the survey, as feared, did not remain an academic exercise. It led to the creation of a new status quo. It led to the creation of the new status quo. Actually, previously the status quo was that it was a masjid. That was the status quo. Now what is the status quo? After the intervention, after the order of the lower court in this scenario, in this particular case, after the order of the lower court, the committee was constituted. When the committee leaked out the information illegally they leaked out a misinformation. It was not an information. It was a misinformation. It was deliberately leaked out by the committee. For that very particular act itself, they have to be punished. But what happened? The court took the information before getting the final report of the survey committee. What they did? They sealed and bounded the particular area of that whole area. And now a new status quo was created. Then the Varanasi court changed the nature of Gyanvapi mosque. It created a new interest in the mosque, a Hindu interest, which did not exist prior to the order of the Varanasi court. Now what happened? New interest has been pushed into this case. That is the Hindu interest. It was the Wazu Khana where the Hindu lawyers claimed to have found a Shivling. The Muslims say plausibly that as in other mosques, this is a fountain from which the water enters. As can be seen in the design of the other mosques, Wazu Khanas do have water fountains in them. So this is a simple procedure. This is a day-to-day findings in the entire world. You could find Wuzu Khanas. This is how the overaction of the lower court and the magnanimous inaction of the top court created a new sensitivity, a Hindu sensitivity, or more appropriate would be to say a majoritarian sensitivity. It is a majoritarian sensitivity. It is a majoritarian sensitivity. I would like to conclude my speech by saying this, that where in a country where minority live in peace is an excellent country. It's a country where people can live in peace, where people can live in harmony, because wherein the rights of the minorities are secured, there comes the magnanimity of the majority. So now what they have did, we are majoritarian, you must accept what we are telling. So that is what we are telling. This is a sensitivity, new sensitivity, the Hindu sensitivity or a majoritarian sensitivity. The court saw to it that in a Muslim space, a Hindu interest is manufactured. This is a Hindu majoritarian state. So you must accept this sensitivity. That is what the court is trying to push and thrust into us. First, the courts created a competing interest. Then they rose about both interests and said that they cannot be seen as partisan. They have to take care of both sensitivities. That is how the word balance enters the judicial lexicon of India. Now, in the case of Babri Masjid, this Hindu interest was created in 1949 by smuggling idols of Hindu gods and goddesses inside in darkness. Then a stand was taken that the sensitivity associated with the interest cannot be ignored. The courts were indulging this illegality, which was rationalized in the name of Hindu sensitivity. Eventually, it led to the ouster of Muslims from that space. The weight of Muslim sensitivity had to be less than that of the Hindu sensitivity. So that is what the case of Babri Masjid. In the case of Gyanvapi Mosque, before our very own eyes in broad daylight, a Hindu interest and sensitivity have been fabricated, aided and abetted by the courts. The court now says that it cannot ignore the claim of the Shivaling. When the Masjid committee said that there is nothing to suggest its existence, the court refused to accept it. There an interesting argument was made. In a country like India, examples of syncretic culture abound. They are normal. Hindu and Muslim symbols can coexist. Why cannot we celebrate both? The court asked. This is an interesting argument by the court. You have to be a very sectarian person to disagree with this noble suggestion. That is how the court is compelling us now. You have to be a very sectarian person to disagree with this noble suggestion. That is how the court has tried to corner the Masjid committee in this case. Can they deny Hindus entry in their mosque if there is a sign, a symbol they regard as their own? The court is asking now. So, eventually this judicial innovation in which the argument of syncretism can be used to force Muslims to share their space will be the matter of discussion for the historians of the judiciary in India. The court also found a way around the Act of 1991, which mandates that the same ensure that the status of religious spaces as they were in 1947 are not disturbed. It said that this provision does not bar anyone from finding out or studying the peculiarities of such spaces. The survey that the Varanasi court ordered can be treated as one such act. So they are finding the peculiarities. So this is not like disturbing or going against or violating the 1991 Act. The court is observing that, finding out or studying the peculiarities of such spaces. So when you are finding or studying the peculiarities of such cases, why are you disturbing the wazu khana? Why are you bounding it? Why are you creating a compound? Why are you getting in the CISF or the central government forces there? For what reason? For what good damn reason? The people who were praying there, who were performing ablution there, were stopped and barred from doing that. If it was really finding or studying the peculiarities of such spaces, then why this happened? The survey that Varanasi court ordered can be treated as one such act. The court observed, what is your problem with this curiosity? The court demands to know. The court asks, this is a peculiar case. This is a broad daylight massacre of judiciary, I could claim. So, what was simple has now become complex. So, the Muslim sensitivity which was agitated by the court action has been made to confront with the Hindu sensibility. And the beleaguered court is now trying to find a balance. One of the members of the learned bench had spoken earlier that this is like majoritarian times. Now we know what this rule is. We have to understand. As I very clearly stated above in my speech before, in a country, in a place, in a state where minorities live in peace, is the country, is the state or a place where majoritarian people are in a magnanimity mood. So to ensure this country is famous for its secularism essence, this country is famous for its magnanimity, the courts must act accordance to law, must act in accordance to law. The courts must take their whip and they should wipe out these people, and the courts must be there to ensure the law, but not to satisfy the sensitivity of majoritarianism. Thank you.